Good morning, everyone. Thank you for joining today. My name is Christy McKenzie. I am Assistant Coordinator of Neighborhood Services, and I work for the Department of Senior Services with Erie County. This is going to be our last session of our series today. A few things I'd like to mention, as we have in the past. This presentation is going to be recorded, so you can access it at a later date. Also, please feel free to ask questions in our Q&A box by typing in and submitting the question. Please refrain from inserting any personal information into those questions, and we'll be addressing all questions at the end of the presentation today. I would like to take a minute to thank those who have made this summer series possible, including our County Executive Mark Polenkars, Tara Nicholson, the CEO for the Center for Elder Law and Justice, and our Senior Services Commissioner, David Shank. At this time, I'd like to introduce our guest speaker, Bob Friedman. Mr. Friedman is a senior partner at Friedman Ranzenhofer with 9 offices, 5 of those in Western New York counties. He lectures on Medicaid and estate planning, guardianships, and probate drawing on his 41 years of legal experience. He has also served on the board of directors of many organizations serving seniors, including Hearts and Hands, Safe in Action, the Brothers of Mercy Campus Foundation, and the Clarence Senior Center and Crossroads House. Welcome, Bob.
Good morning. Thank you, Christy, and thank you to the Center for Elder Law and Justice and the Erie County Department of Senior Services. Both organizations are a great resource for seniors. As I always do in my seminars, I just have a couple warnings before we start. First off, that this is not a substitute for legal advice. You need to speak with your own advisors, your own tax advisors and legal advisors and investment advisors to see what's best for your particular situation. This area of the law is constantly changing and subject to different interpretations. In the interest of time, since we do have a great deal of information to cover, I will hold off answering questions until the end. I have the advantage of being the last speaker in this series in that many of you have probably already seen the excellent presentations on estate planning, Medicaid, elder abuse, and nursing home rights, which all play into what I will be talking about here as far as guardianships for incapacitated people. I've handled guardianships in throughout Western New York in 6 counties, both contested and uncontested guardianships, representing both petitioners and what's known as the alleged incapacitated person that the petitioner is trying to obtain guardianship over. There is a free guide on our website, WNY-Lawyers, which will cover in detail everything that I'm going to be speaking about today. It's a 43-page guide, which is free, entitled Stop Elder Abuse with New York Guardianships. The 2 situations where guardianships come up the most often are, first off, and I just spoke with someone about an hour ago, which is a very common call we get 2 times a week, is that the caller said that her father was just admitted to a hospital and will be going in for long-term care, and he never signed a power of attorney. And at this time, they need a power of attorney immediately in order to apply for Medicaid, complete the nursing home applications, and so forth. The other situation is when there is already is a power of attorney, and that power of attorney is financially abusing the elder person by using their credit cards, depleting their bank accounts, and so forth. So for a case example, which summarizes what happens quite often, we have Mary, who is a widow. She's age 94. Her daughter, Sally, is her agent. She appointed in her power of attorney. And she has 2 other children, Tom and Kathy. she owns her home and has a $200,000 bank account. What often happens, or what often happens, is that the power of attorney, usually a relative, may be stealing from the elder. In addition, as part of the plan, very often that particular child, say Sally in this instance, is alienating her mother through isolation and brainwashing her about how her other children are trying to get her money. Sally has a gambling problem. She's been using Mary's credit cards, making withdrawals from Mary's bank accounts, and she won't let her mother answer the phone at all. Tom and Kathy have been calling over to the house, trying to make arrangements for them and the grandchildren to visit, and she is isolating her mother. Before we decide whether or not a guardianship is necessary, the first question is always, are there alternatives to guardianships? These guardianships for incapacitated persons are really the very last course of action if there are no alternatives. It's a last resort. Guardianships may be unnecessary. That's something that we have to screen out when we get calls about people that want guardianships. And because it is an excessive intrusion upon an individual's liberty interests. And it may, and it usually does, cause hard feelings by those that are bringing the guardianship proceedings. So if Tom and Kathy are trying to bring a guardianship for their mother to stop Sally abusing their mother, that may even further alienate Mary from her children, Tom and Kathy. So the questions I usually ask when someone says they need a guardianship is that, are there joint assets? There's a number of considerations. Are there joint assets? Because the child may need access to the parent's assets in order to pay for their nursing home care or household expenses. Is there a power of attorney? So very often people are calling, they need a power of attorney in order to manage their loved one's finances. One of the big misunderstandings is that powers of attorney are not a substitute for a will. They are no longer in full force and effect when someone dies. Powers of attorney can be either immediate or springing. They can go into effect when the individual signs it, or can go into effect at a later date after a certain event, such as a doctor certifying that the individual is incapacitated. In your powers of attorney, you can designate whether or not the agents must act together or whether they can act separately. And you can authorize someone through your power of attorney to do all financial transactions on your behalf. So the power of attorney law that went into effect in 2009, there's a separate statutory gift writer if you want to authorize gifts in excess of $500 per year. And this has to be witnessed by 2 witnesses. This can be very effective for emergency Medicaid planning, which we'll be talking about. So sometimes, even though someone may have signed a power of attorney, they may not, and this happens quite often, they may have signed a power of attorney and not also execute the statutory gift writer, which would authorize emergency Medicaid planning. So either the power of attorney is old or does not have a statutory gift writer. And in that case, even though they do have a power of attorney, very often a guardianship will still be necessary for emergency Medicaid planning with promissory notes, which we'll talk about shortly. Living trusts are also an alternative to guardianships. If someone has created a trust with trustees to manage their assets and they funded the trust, then their trustees would have access to their funds to pay for their living expenses and nursing home costs. There's a number of advanced directives that everyone should have And those include healthcare proxies and living wills. And if people do not have these advanced directives, then a guardianship may be needed, not only for their financial well-being, but also to make healthcare decisions for them. Healthcare proxies came about through legislation in which you appoint a healthcare agent to make healthcare decisions for you and an alternate. And living wills came about as a result of a Court of Appeals case in which you can specify what care you do or do not want, if you are in a coma, with terminal illness, a non-terminal illness, and designate whether or not you want tube feeding or artificial hydration. So these can be very valuable as being advanced directives. You have a constitutional right to refuse treatment, but if you aren't able to communicate that, then it's very important that you have a healthcare proxy and living will. Some other advanced directives also are MULS and PULSE, medical orders for life-sustaining treatment, or physician's orders for life-sustaining treatment, in which you complete those documents with your doctors, and those are more detailed than your healthcare proxy or your living will. Also, HIPAA authorizations. Any of you have been to your doctors, you've been to a doctor visit, you're asked to sign a HIPAA authorization, authorizing who can have access to your protected medical information. The HIPAA authorization may be contained within your, or should be contained within your living will. And also there's a HIPAA authorization can be contained in your power of attorney. So your agents can have access to your medical information, and even for your agents to be able to talk discuss your billing with your medical providers, they would need a HIPAA authorization. Social Security representative payee, that's where you designate someone to receive your Social Security. Assisted outpatient treatment is someone, it can be a court order for someone with a mental disorder. So the guardianships for incapacitated persons are covered under Mental Hygiene Law Article 81, and they are different than the article, what's known as the Surgeons Court Procedure Act 17A guardianships. The 17A guardianships are for those people that are developmentally disabled or intellectually disabled. So there's a number of initial considerations before that must be considered whether you decide to go forward with a guardianship proceeding. And the first consideration was what we just talked about. Are there any alternatives to guardianship proceeding? That's what you need to consider, and also the court's will also want to know whether there are already alternatives in place that obviate the need for guardianship. As we discussed, joint ownership, powers of attorney, healthcare proxies, all those documents in the hands of correct agents may eliminate the need for guardianship. It's a second consideration, is the guardianship necessary in order to apply for Medicaid and emergency Medicaid planning? The process of applying for Medicaid is very burdensome, especially for elderly people that may not, and especially in these times of COVID-19, which a great deal of records must be gathered and information put together, so that it may be necessary for a guardian to do that, and also for emergency Medicaid planning. One thing they will look at in the petition, if you're asking for authorization for the guardian to make gifts to the children for emergency Medicaid planning, they want to know whether court will want to know whether that's consistent with the incapacitated persons plan in their will. Also, will the guardian's powers be unlimited or definite? Is it just needed for a specific purpose? Also, will the guardian need any specific or special powers, such as the guardian may be seeking to move the incapacitated person to their home if they live out of state, or make gifts of the incapacitated person's property. Sometimes the guardianships may only be needed for a limited or single transaction. If the incapacitated person has already executed a healthcare proxy, there may be no need to have a guardian for their person, only for their property. So guardians can be appointed for control over a person's person, make healthcare decisions for them and decisions where they'll be living, and or a guardian over their property. There's also a question of whether the guardianship will be contested. The incapacitated person has a right to an attorney. They may contest the guardianship, and they may be successful in contesting the guardianship. As I said, this may create even further bad feelings among family members. Also, it's a low threshold to find someone incapacitated under the guardianship mental hygiene law. They don't have to be declared to be insane. It's only that they have their functional level. Because of their functional levels, they may be a danger to themselves, either personally or their finances may be in danger. So even though someone has been found to need a guardian, they still may have the capacity to execute a new will. So that if you're trying to get a guardianship for a family member, even if you are successful in having a guardianship and there's bad feelings, they still would have what's known as testamentary capacity, and your father and mother could still change their will and write you out of the will. Another consideration is there an urgent need for the guardianship? Such as if the alleged incapacitated person, if their well-being is in danger because they need to be put into skilled nursing home as soon as possible, or if they're in danger of having their assets depleted by the power of attorney or some other family member. So we need to look to see whether they are the victim of elder abuse, fraud, and manipulation. Also, in considering whether to start this guardianship, are there standby guardians available? So in the petition, you could ask for the guardianship for Mary. Tom could be requesting that he be guardian and Kathy be standby guardian in case the time comes where Tom is not able to be the guardian. Another consideration before we start the guardianship proceeding is there sufficient evidence that the AIP, that's the incapacitated person, is incapacitated and needs a guardian. One thing that we face as petitioners in bringing guardianship proceedings is that, for instance, Tom and Kathy have been cut off from Mary's life. They may have they may not have any access to Mary's medical records or her financial records, and they may never have that. So developing evidence to prove that a guardianship is necessary may be very limited. They do not have a right to see her medical records, and it's not that medical records necessarily are needed to prove that a guardian is needed. It's more of what they call a functional analysis, and it would be based on possibly on testimony by people that are familiar with Mary. So that's a consideration. Very often, you can still be successful as a petitioner in guardianship with very little evidence, but it does may require a lot of creativity in order to develop the evidence necessary to prove that the guardian is necessary. So that's one of the primary factors that we discuss with clients, that we would discuss with Tom and Kathy, on what sort of evidence that do they have that Mary does not have the capacity to properly care for herself, or care for her financial records. And also, we're going to need names and addresses of all parties that must be served with the order to show cause. So, as I said, who is the guardian? So the guardian can be appointed either for the person or property of the person. So Tom and Kathy may be be the petitioners, and they may be requesting that they be guardians. Now the petitioners can be any of the following people. The petitioner could be the incapacitated person themselves could petition to say that they need a guardian. Anyone that's entitled to a share of the incapacitated person's estate for petition. Anyone that's an executor or administrator of an estate of which the person may be a beneficiary. A trustee of the person's trust. Anyone that lives with the person. A person that's concerned with the welfare of the incapacitated person, including the Department of Social Services in the county where the person resides. Also, the CEO of the nursing home or other facility where the petitioner lives. So, in order to obtain guardianship, the petitioners prepare a petition which is filed with the Supreme Court, and with an order to show cause, the judge signs an order to show cause, specifying, among other things, who the court evaluator is going to be. We'll talk about the court evaluator in a moment. Setting forth the hearing date, which the courts consider these to be expedited matters, and they will expedite a hearing date. Not necessarily if the hearing will actually be held on that first court date. It rarely is if it is contested, but they will set a hearing date, and the order to show cause states who must be served with the order to show cause and in what time period. So the order to show cause, the filing of a petition, and the signing of the order to show cause starts the guardianship proceedings. So there are people that are required to be notified, interested people that must be notified and served with this order to show cause, to give them an opportunity to come to court and to be heard either in favor or against this guardianship proceeding. So the person's spouse, parents, adult children, and adult siblings must be notified. So even a widow with no parents and no children, their brothers and sisters must be served, wherever they may be, anywhere in the world, they must be served. Anyone that lives with a person must be served with the order to show cause. Healthcare proxy and the healthcare agent and the power of attorney agent must also be served, because the guardianship proceeding may affect the powers of these agents. The court could possibly, and does in certain circumstances, revoke the power of attorney when there is abuse by the power of attorney agent. If any person or organization with a personal relationship with a person that demonstrates a genuine interest in promoting his or her interests. If the person is receiving public assistance, the Department of Social Services must be served. If the person is living in a facility, the chief executive officer, usually the nursing home administrator, has to be served with the order to show cause. If the person is residing in a mental hygiene facility, mental hygiene legal service must be served. Anyone that has a joint that is on the person's bank account as a joint owner, they must also be served, because the funds in that account may be affected. And the court can direct anyone else that they feel is necessary to be served with the order to show cause that may have an interest in whether or not the guardian is appointed. As I said, in the order to show cause, the judge will name a court evaluator. It's usually an attorney. It's not always an attorney. And the job of the court evaluator is to be the fact finder for the judge. The court evaluator is also served with the order to show cause and petition. The court evaluator will speak with the alleged incapacitated person and some of his or her relatives and other people that may have an interest. And the court evaluator may also ask the judge for a court order to obtain the person's medical records. We need a court order for that. Also, the job of the court evaluator may be to prevent waste or loss of the AIP's property during the pendency of this proceeding to if the person is a victim of financial exploitation. And also the court evaluator or a temporary guardian. Temporary guardian could also be appointed by the judge in the order to show cause if it's necessary to take control of the person's assets to avoid them from being depleted, or if it's an emergency situation where a person may be in danger living in their home and maybe have to be placed in a facility. So this temporary guardian or the court evaluator may be authorized to open a bank account in order to deposit the person's assets to protect them while the guardianship is being carried out. So the petitioner brings the proceedings. So we have petitioners, could be any number of people that are interested in the well-being of the person. And they have to provide clear and convincing evidence with factual allegations that the person is incapacitated. They have to show that the person is likely to suffer harm because of an inability to provide for his or her own personal needs or property management. They must also show that the person cannot adequately understand and appreciate the nature and consequences of such inability. So they must show that the person does not really realize that they're being taken advantage of either financially or that the decisions that the person's making are not in their best interest. The courts are going to look to give the incapacitated person as much freedom as possible in crafting or ordering this guardianship to give them as much freedom as possible. And as far as the level of evidence, it's a pretty low threshold as far as a finding of incapacity in order to protect the person's well-being. So, like I said, it's more of a medical rather than, and very often we don't have the medical evidence. It's more of what they call a functional analysis, determining what the person's functional level and limitations are. They will look at whether the person needs management of activities of daily living, look to evidence. Do they understand the nature and consequences of their inability to manage their activities of daily living? The court will look to their preferences, wishes, and values with regard to managing the activities of daily living and the nature and extent of their property. So the court will appoint a guardian if it is necessary to provide for the person's personal needs. And what the standard is, they're going to look at the least restrictive form of intervention of the person's personal and property management needs, while ensuring that the greatest degree of independence and self-determination. So they may still allow the incapacitated person to decide where they want to live, whether they still want to live at home or whether they need to go in assisted living. They may still leave that open. If the person's not able to make that decision, then they may leave it up to the personal needs guardian to determine where the person should live If there are people that are having a bad influence on the guardian, they're taking advantage, manipulating the incapacitated person, the court could limit that. The court could also provide that that the guardian make sure that grandchildren have access to the person. If in the past, for instance, a situation where Sally preventing Mary's grandchildren from visiting her, the court order could provide to make sure that that Mary does have access to her grandchildren, and that there is some sort of time when she'll be able to see her grandchildren and not be isolated from her grandchildren and other family members. So the guardian's powers and responsibilities. So we can have guardians of the property appointed, and or the same person could be appointed as property as guardian of the person's property and person. Property management powers include paying bills. They could sell real estate if necessary. For instance, if it was necessary for them going to a nursing home. Authorize the release of confidential records. Make gifts to family members. That can be provided in the guardianship order if it's been what their pattern in the past has been. Enter into contracts. Collect all their assets. Create trusts. Prepay funeral accounts. Prepay for funeral as part of the Medicaid planning. Personal needs guardians would have powers, can be given powers to manage medical treatment, determining living accommodations, make decisions about social activities, as I said, with visiting grandparents and friends, and assess travel if appropriate. So the guardian's ability to apply for Medicaid on behalf of the AIP falls both under property management and personal needs powers. There are some basic responsibilities that the guardians have. Guardians of the person must visit them at least 4 times a year, because a family member would be more often. They must, their first report is due 90 days after they qualify by filing their oath with the county clerk. And then they have to file reports every year in the month of May as to the activities. They're also required to take a guardian course. So one thing to keep in mind is that, and something that people have to understand, is that guardianship proceedings are really adversary proceedings. The petitioners, Kathy and Tom, are really asking the court to take some of their mother's rights away to make decisions on her own, but for her own protection. So for that reason, Mary has a right to have her own attorney in these proceedings. She may not be agreeable to the guardianship. She may or may not have an attorney. The court will still want to have the judge in a very non-threatening manner. The judge will want to have a dialogue with Mary to see, does she really want the guardianship? If she does not, if she wants to contest it, then the hearing may be necessary. So for that reason, there has to be separate legal representation for Mary, either her existing attorney or the court may appoint an attorney for her, or she may have if she's in a nursing home facility, she may have the services of the mental hygiene legal services. So going back over some commonly asked questions about guardianship proceedings, in choosing an attorney to represent you in a guardianship proceeding, whether you're an incapacitated person, an interested relative, or petitioner, is find out what the attorney's experience is with guardianships and also with trials, because these can result, contested guardianships can result into quite a bit of pre-litigation discovery and a hearing similar to a trial. And also, the attorney needs to have knowledge about emergency Medicaid planning. Another consideration people want to know if we get calls from petitioners, who is going to pay the legal fees? As I said, there can be numerous attorneys involved with the process. There's a court evaluator's fee that has to be paid, the petitioner's fees, the incapacitated person may have fees, or if they're hiring an attorney. So the situation is that the court, if the case is settled, or if the petitioners are successful in the guardianship proceeding, the court can order that the incapacitated person pay the legal fees of the petitioner. And usually they would, in a successful proceeding, they would have the incapacitated person pay the court evaluator's fee. The court evaluator interviews everyone and submits a report, hopefully by the first hearing date. That, of course, with COVID-19 and other problems, the court evaluator may or may not have their report and recommendations ready at the first hearing date. So the case may have to be adjourned because of that. The judge wants to, the court evaluator's report is not binding on the judge's decision. It does give the judge a sense of what's going on, more detail as to what the facts are. It's a summary of things. The court evaluator very well will stay on through the proceedings, be available during, if it's contested, be available during court conferences and during the hearing, if there's a hearing necessary. So the cost of guardianships vary greatly depending on how long they're gonna transpire. For petitioners, the guardianship, the cost for the cost of the petitioners for bringing the action, it may be hourly if it is contested, or it could be a flat fee if it's uncontested, involving maybe only a couple court appearances. So how long does it take for a guardianship to be guardian to be appointed? Well, the time periods have ranged all the way from 1 month to 10 months. Normally, if the action is not, if it isn't contested, which would be a typical situation where there hasn't been financial abuse, when we get the contested proceedings, the power of attorney, Staley in this instance, is going to hire her own attorney to protect her interests because she's been accused of stealing from Mary. So she's going to be hiring an attorney, and she may be contesting the guardianship, saying that the power of attorney should not be revoked and that she should continue on, and her reputation is at stake. So it could be contested by her. The incapacitated person may be contesting it. So we need to look at if it's not being contested. Usually a situation where it's not being contested is a situation where it's needed for emergency Medicaid planning, and there's been no financial abuse. So that can only take a month or two. If it's contested, it could take up to 9 or 10 months. Go through, it could be discovery demands like in litigation, and various pretrial conferences, and then a hearing, which could take a day or two. And then from that point, the judge, if it is contested, the judge may or may not be making a decision at that time. The judge may need a week or two to make a decision. So, but for the most part, these guardianships can be concluded within 2 or 3 months if it's not contested, and if a temporary guardian could be appointed if there's some dire need to protect the incapacitated person in order to manage their assets and prevent further financial abuse. Again, who does the attorney represent? So there is So someone that's representing Kathy and Tom as petitioners, they are actually an adverse interest to their mother. So they are only representing Kathy and Tom, the petitioners. If this attorney's represented Mary in the past, then there's going to be a conflict because they're asking to have a guardian appointed for her, which she may or may not agree to. So we have to keep the lines separated as to who's representing who. So if petitioners are hiring an attorney, that attorney is only representing them. Even though in the long run, we know we're looking to protect Mary and it's in her best interest, it's still an adverse interest. And it's what you need to keep in mind is that, as I said before, we're trying to take away some of Mary's rights for her own part of her civil rights to make her own determinations in her best interest, which only the Supreme Court judge will decide on if it's contested. Can a family member be appointed as a guardian? It's generally favored unless there's doubts as to their ability to do that. Some judges in the past have preferred not to appoint family members. So it's not guaranteed that a family member will be appointed as a guardian, even though that they are the petitioners, Kathy or Tom may not be guardians. There may be doubts as to their ability to do that. Will a hearing be necessary? Will actual hearing be necessary? So if it's contested, then there may have to be a hearing conducted. But still, the judges will most likely still want to hear if the incapacitated person is agreeing to the guardianship. They will still want to talk to them directly, which is being made more difficult in these days of COVID-19. But if they're agreeing to that, unless there's unless their appearance is excused somehow, and their appearance may be remotely done. Some of the courts are back to doing in-person appearances on guardianships, depending on what county you're in. But the judge will still want to put something on the record as far as the necessity for the guardianship, even if it's not being contested. And if the incapacitated person is able to express their wishes, the judge will take that into consideration. And as I say, in most cases, the judges will try to make the incapacitated person feel as comfortable as possible in the setting, because it can be very confusing and intimidating for anyone, of course, to appear in a court. But most of the judges are very understanding and try to make a person feel that they're in a safe place when they are talking to the judge. So the use of guardianships for Medicaid planning, I said this comes up very often, and without going into great detail as far as Medicaid, as you may have heard in the prior presentations, there are quite a few protections for the home, which can be gifted to your spouse, to siblings with equity interest, to disabled children. And, talk to your advisors about that. There are a lot of protections that are not subject to the look-back period or any sort of penalty. So here again is what I'm emphasizing is that you need to speak with your own advisors, because just because your neighbor was able to qualify for Medicaid, each particular case is different. You need to have your attorney analyze your assets, how they're held, what gifts have been made. So one very common way of preserving your assets for those who have never done any Medicaid planning is what's called emergency Medicaid planning with promissory notes. And this is well accepted in the courts. We have had many courts order the guardians to make gifts using promissory notes. You've probably heard about it in the prior presentations, but basically someone who's never done any planning, who has either a guardian that's been granted those powers, or a power of attorney with who has a statutory gift rider, can gift their property, gift their assets. It's a very precise calculation. When they're already in the nursing home, even though they've never done any Medicaid planning, with the use of promissory notes, where only half of their assets will have to be used for their nursing home care, and the other half can be retained by their family as a gift. It's perfectly legal, and this is something that's done. And of course, time is of the essence, and that's why we get, very often we get calls with people. They may have a power of attorney already in full force and effect, but it does not have that gift rider. So it's incumbent on getting a guardianship appointed as soon as possible before the nursing home bills mount, which can be up to $500 per day. So it's very time crucial that if you don't have the, you want to do the emergency Medicaid planning, someone that has, such as Mary, that has a house and substantial assets, half, as I said again, it's not, I'm just speaking in broad terms, half the assets can be preserved for her family, can be gifted to her family, and only the other half will have to be used for nursing home care. It's widely accepted procedure, but it has to be done correctly. It has to be done with someone that has the authority to do that, either your agent with a statutory gift rider or a guardian. So this is what so for some cases, that is the sole reason that we brought guardianship proceedings, in order to preserve their assets and so that they can gift half their assets to their children, and only have to use half their assets for their nursing home care. Okay. So that's why I generally say a power of attorney with advanced planning, and hopefully this will motivate people to do their estate planning. A power of attorney with a gift rider can be one of your most valuable tools as far as preserving your assets in case there is nursing home care that needs to be funded. In response to financial abuse, so financial abuse can take many forms, and about over half of the financial abuse is by family members or caregivers. You all have to, as far as preventing financial abuse, you have to be very careful. We've seen even caregivers from home care agencies have been stealing from people that they're caring for. So it's very important that you do keep an eye out on your family member. Financial abuse takes many different forms, elder financial abuse, from forgery, fraud, outright stealing. There's power of attorney abuse, there's scams. It could be from a very trusted person, such as a caregiver. The perpetrators of elder financial abuse consist of adult children, caretakers, neighbors. We've seen what's happened, neighbors abusing, and they're the person, friends, bank employees, pastors, healthcare providers. So you need to be aware of that. So guardianships, as far as addressing financial abuse, as I said, they can appoint temporary guardians to immediately stop the financial abuse. They can issue injunctions if someone's about to transfer a house. We've had situations where elderly person was just about to sign over and gift for real estate to a deed, real estate to another person. We were able to stop that by initiating a guardianship proceeding. As I said, the court evaluator can be given the authority to preserve the assets. And the guardian can also obtain a summary turnover orders to force people that are in possession of the person's assets to turn those over. So as far as preventing financial abuse, people that talk about their finances with third people, third parties, are feel better equipped to prevent elder financial abuse than those who keep everything to themselves. Many people, especially after they're suffering financial abuse, they feel very guilty. They feel stupid, like they've done something wrong and they're to blame. So it's good to keep a continued dialogue with third parties regarding your finances so that they're aware of it. Even between spouses, we see very often that especially husband doesn't share very much financial information with his wife traditionally. And then when anything happens to when the husband gets incapacitated or passes away, the wife may have no idea. So you need to have an objective third party review all your financial statements and discuss with your legal advisors, your financial advisors, and your tax advisors what your best options are. There's various tax issues that have to be discussed in estate planning, if you're gifting real estate. In these days of online banking, it's really best to get to know your banker and build a personal relationship with maybe with a local banker so they can keep an eye out. And the banks, I know some of the local banks are training their staff to look out for signs of elder financial abuse through other people taking an interest in your financial matters. And above all, if you're going to do a power of attorney, appoint a trustworthy person to do that. There's been all sorts of safeguards built into powers of attorney as a result of the legislation in 2009 and 2010. And there's pending legislation to change the powers of attorney. But there are many built-in safeguards. You can appoint a monitor over your power of attorney. But above all, you're giving this agent a lot of authority. So discuss that with your attorney and your family as to who would be your best power of attorney. And as usual, never share your personal information, including social security numbers, account numbers, and so forth, with anyone that requests it on the phone or the internet. It's a constant problem, ongoing every hour of the day, where people are misidentifying themselves as bankers or government officials trying to get your information. Just trust your instincts. If you think it's you're being exploited, you're not required. Don't listen to threats about government authorities coming after you. Consult with a third party, someone that you trust about that. And also keep all of your important paperwork under lock and key and shred your receipts. So we've just about run out of time. This, as I said, all this information is available as a free guide on my website, WNY-Lawyers. If we don't get to all the questions today, feel free to call me or email me with any of your questions. And we covered a great deal of material today, and I just hope it gives you enough basic information to know how to proceed in the future. Thank you for your attention today.
Thank you, Bob, and thank you all for joining. There are no questions at this time, but like you said, Bob, you did cover quite a bit of information. There will be a brief survey that pops up. If you could have a minute to fill that out, we'd appreciate it. And if you still have any other legal questions, you can feel free to call the Center for Elder Law and Justice, our partner with this summer series, at 3087, extension 267. They are offering free legal consultations. And I hope that you've enjoyed the virtual Elder Law Day Summer Series. You can find all these presentations and PowerPoints available on our website at erie.gov/ELD. And stay healthy out there. Thank you again, Bob.
Thank you, Christy.